Suzanne Rabb, and this is my presentation on the impact of the General Data Protection Regulation on healthcare professionals. The General Data Protection Regulation, or the GDPR, brings about important changes in the way in which healthcare professionals use and collect personal data. Hospitals and consultants in private practice have needed to comply with the regulations since the 25th of May 2018. Now, over a year on from implementation, this presentation will look at what has changed and what consultants should be doing to satisfy themselves that they are complying with their obligations. Ensuring that personal data is kept private and confidential is key to the patient-consultant relationship. And impermissible disclosures can have serious consequences. For example, the Information Commissioner's Office has fined a UK private healthcare firm £200,000 after IVF patients' confidential communications were made available online. That penalty was, however, limited by the constraints of the previous law under the Data Protection Act 1998, which most consultants will be familiar with. There are some similarities between the Data Protection Act and the GDPR, but there are some quite significant additional requirements under the GDPR and an increased risk of bigger fines and enhanced administration. Many data controllers will have invested a great deal in getting ready for compliance last year on the 25th of May 2018. But as will be very clear from this quote from the Information Commissioner, compliance with the GDPR is not a one-off exercise, but it requires sustained effort. The huge rise in data breaches, coupled with the increase in public awareness, has led the Information Commissioner to focus attention on the most important sensitive cases. But it's not just high-profile issues such as the Cambridge Analytica scandal, which have attracted media attention. And really, as is clear from the statement by Mark Zuckerberg, the reputational consequences of data breaches can be very difficult to recover from. It's interesting that since the GDPR has come into force, the Information Commissioner has ramped up enforcement and has announced plans to impose a record £183 million fine on British Airways after a data breach last year affected around 500,000 customers. And the ICO cited poor security arrangements that led to the breach of logins and credit card information and other personal data. This fine would represent the largest that the ICO has ever issued, eclipsing that was imposed on Facebook due to the Cambridge Analytica incident that affected 87 million users. But again, that was constrained by the powers that the ICO had under the previous legislation. But now that's all changed, because since the GDPR came into force, the regulator can fine a company up to 4% of its worldwide turnover for data breaches. So what has really changed? Some people describe the shift from the old regime as not so much a radical overhaul, but evolutionary. And it is the case that key principles, fair and lawful processing, purpose limitation, minimum storage, transparency, data quality and security, which were enshrined in the previous legislation, do remain in the current regime. But the GDPR seeks to bring data protection into the digital age, and a key focus is on accountability. Data controllers and their processors will need to demonstrate compliance, and this puts a much sharper focus on having in place appropriate policies and procedures and ensuring that there is an appropriate governance framework. That is to say, reporting channels and a person responsible for data protection in order to secure compliance. But even though the GDPR has been in force for some time now, and there has been a lot of preparation devoted to securing compliance on day one. Nevertheless, some questions remain as to how the rules will apply in practice and how strenuous the enforcement practice will be. Brexit is unlikely to bring about a significant change, at least in the near time, as the government has committed to preserve the existing regime. Moreover, if the UK is going to continue to share data with the EU with the flexibility that it currently enjoys, it will need to ensure that it offers an equivalent level of protection to data subjects' rights to that afforded under EU law. So let's now look at the changes and the practical impacts before translating that into consultant practice. So here are some main drivers of the GDPR. So despite the attempts at harmonisation, there are opportunities for member states to take different approaches. But we see here that the core aims of the regulation are to protect fundamental rights and freedom and contribute to the economic and social progress, enable free movement of personal data within the EU, and generally bring the regime into the digital age. As noted, the changes may be described as evolutionary, not revolutionary, but the fundamental aim remains to be the protection of fundamental rights and freedoms, and thereby contribute to social and economic progress, allowing free movement of personal data within the EU and bringing the treatment of personal data into the digital age. But despite attempts at harmonisation, there are still some opportunities for member states to take different approaches. And we're already seeing some disparities in enforcement action across the member states. So let's contrast very significant action against Google by the French data protection regulator, with fines of 50 million euros being the largest data protection fine ever. So there remains the possibility of multiple enforcement actions in different EU member states for those entities without a main establishment in the EU. So that does bring with it the possibility of forum shopping by complainants seeking the most friendly regulator. So now let's take a closer look at some of the building blocks of the GDPR and what these mean in practice. The concept of personal data is very wide, and under the GDPR, any information identifying a data subject or information relating to that subject, either alone or in combination with other identifiers, will qualify as personal data. Pseudonymised personal data is still personal data. That's where there may be data residing in different spreadsheets with identifiers, so that when you put the two pieces of data together, it's possible to identify an individual, perhaps from an email address. Personal data can be factual, such as a name, email address, location, or date of birth, or it could be an opinion about a person's actions or behaviour. So if you're holding personal data on EU citizens, the GDPR, like its predecessor, will almost certainly apply. And this will include data about patients, but also staff, employees, and contract data that a practice is holding. Personal data processed in a healthcare environment will typically include names, addresses, including email addresses, medical information, and for self-pay patients, perhaps financial information. Medical images and communications on social media, where it's possible to track those, will also be considered as personal data. The GDPR introduces new requirements for both data controllers and for processors. In the context of a private healthcare practice, the data controller could be an individual hospital, practice, consultant, or any combination of these. A data processor could be the practice manager or an employee, such as a receptionist inputting data, or a secretary, It could be an IT consultant or anybody who acts on the controller's or processor's behalf. And it will be important for individual consultants and practices, whether they're operating as sole traders, partnerships, or under some other structure, to satisfy themselves that they are compliant with their data protection obligations. The GDPR has a very wide territorial scope and applies to controllers and processors located in the EEA, with some exceptions. It has a wider territorial scope than its predecessor, so will include processing in the context of activities of an EU establishment, i.e. where the controller is located. But even for those outside the EU, if they're offering goods and services into the EU or monitoring the behaviour of EU citizens, the GDPR will almost certainly apply. And this is because individuals might lose the protection of the GDPR if their personal data is transferred outside. So on that basis, the GDPR will restrict transfers of personal data outside the EEA unless the rights of the individuals in respect of their personal data are protected in another way, or a number of limited exceptions apply. But broadly, this ensures satisfaction that equivalent safeguards apply in the destination country outside the EU. Within the broad category of personal data, different rules apply depending on the type of data, especially sensitive personal data, which is subject to some more stringent rules. And this will include personal data revealing race or ethnic origin, political opinions or religious beliefs, trade union membership, or in the healthcare context, genetic data, biometric data, or data concerning a person's health, sex life, or sexual orientation. So it's safe to say that assume that personal data is involved given the wide context, and there is a high bar for compliance, which really shifts the focus to data minimization or even anonymization. This doesn't mean retaining the minimal amount of data possible, but consistent with what the needs of the organisation are. Consider also the scope for pseudonymization of personal data, as this is likely to cause less harm to the affected individuals in the event that there is a data breach, and consider the best way of keeping personal data secure. Additional requirements apply to special category data, and this will be particularly relevant to the healthcare sector. But while the GDPR is often held up as a gold standard of international data protection, it's well to keep in mind that some other jurisdictions do treat certain categories of personal information more stringently. For example, Maryland and North Carolina expand on the definition of personal information to include biometric data, health data, and other government identification numbers. And there are also federal acts in the United States that mandate that certain health and financial data are protected. But it is fair to say that the GDPR perhaps applies the most stringent categories on an international basis. For the first time ever, data processors will have primary obligations to comply with data protection law. The data processor, as noted, will be acting under the instructions of the data controller, but they also need to maintain adequate documentation, carry out data protection impact assessments where required, and appoint a data protection officer where required. So even those processing personal data on behalf of the controller will be subject to the law, increasing the compliance burden across the supply chain. As noted, the GDPR has brought about an increase in the maximum level of fine that can be imposed, up to 4% of turnover worldwide of the relevant controller in respect of more serious breaches. It's not clear how the percentage fine would be applied in the case of a practice, but it's likely that when fines are imposed on parties, their economic situation will be taken into account. and the possibility of fines will focus the mind of consultants and others on the burden of compliance. And this perhaps puts the focus that contractual terms will need to be looked at very carefully to ensure GDPR compliance, where the controller has got relations with third parties for processing of personal data or other outsourcing arrangements which are dependent on the transfer of underlying patient information. Data controllers are required to notify breaches to the National Supervisory Authority, which in the UK will be the Information Commissioner's Office, without undue delay and in any event within 72 hours of becoming aware. And processors must also inform their controller without undue delay after becoming aware of such a breach. However, the processor does not have to notify the ICO about breaches that are unlikely to result in a risk to the rights and freedoms of natural persons. But given this enhanced environment, it's led to a number of precautionary breaches, and the ICO anticipates that at least a third of notifications it receives are perhaps unnecessary. But this raises a very delicate compliance issue of when should a notification be made, and it's understandable that data controllers have erred on the side of caution in making those notifications, and they need to include a description of the nature of the breach, the identity and contact details of the data protection officer or another contact point, the detailed consequences of the breach, and any measures proposed or taken by the controller to address that breach. The data protection principles form the bedrock of the GDPR, requiring that personal data is processed lawfully, fairly, and in a transparent manner, that it's collected for specified, explicit, and legitimate purposes, that it's adequate, relevant, and limited to what's necessary in relation to the purposes for which it's processed, that it's accurate, and where necessary it's kept up to date, that it's not kept in a form which permits identification of subjects for longer than is necessary for the purpose for which the data is processed. And it needs to be processed in a manner that ensures security, using technical and organisational measures to protect against unauthorised or unlawful processing. And the controller is responsible for and must be able to demonstrate compliance with those principles, summed up in the principle of accountability. The GDPR puts a much greater emphasis than previously on individual rights, and these include the right to withdraw one's consent to processing at any time, the right to receive certain information about processing activities, to request access to personal data, to prevent its use for direct marketing, to ask that the data controller erases personal data if it's no longer necessary in relation to the purposes for which it was collected, to restrict processing in certain circumstances, or challenge processing which has been justified on the basis of legitimate interests or in the public interest, to receive a copy of an agreement on which personal data is transferred outside the EEA, to object to decisions based solely on automated processing, including profiling, and to prevent processing that's likely to cause damage or distress to the data subject or anyone else. And not surprisingly, this increased focus on individual rights has led to many consumers and patients sending subject access requests to practices asserting these rights. The GDPR introduces a right for individuals to have their personal data erased. The right to erasure is also known as the right to be forgotten, and individuals can make a request for erasure verbally or in writing. The data controller has 1 month to respond. This right is not, however, absolute and only applies in limited circumstances. The right is not the only way in which the GDPR places an obligation on the controller to consider whether to delete personal data. The GDPR introduces a duty for the data controller to appoint a data protection officer, or DPO, if it's a public authority or body, or if it carries out certain types of processing activities. The DPO must be independent, an expert in data protection, adequately resourced, and report to the highest level of management. And in some instances, several organisations can appoint a single DPO between them. Not all consultant practices will need to appoint a DPO, and it's essential to get advice on when the requirement will apply. The GDPR has brought with it enhanced requirements for lawful processing, and as a matter of practice, controllers will need to have one or more legal justification to process personal data. It's necessary to consider what is the most appropriate justification, and the general practice of justifying processing by consent should probably cease, because that can be highly vulnerable, as it can always be withdrawn. At best, a justification of last resort, which brings forth additional requirements. So the data controller must only process personal data on the basis of one or more of the lawful bases. Let's look in more detail at consent. A data subject will consent to processing if they indicate their agreement either by a statement or a positive action. Consent requires affirmative action. Therefore, silence, pre-tick boxes, or inactivity are unlikely to be sufficient. And if consent's given in a document which deals with other matters, then that consent must be kept separate from those other matters. Data subjects must be able to withdraw that consent at any time, and withdrawal must be promptly honoured. Consent may need to be refreshed if you intend to process personal data for a different and incompatible purpose from that which the consent was originally given. So unless a consultant can require on another legal basis, explicit consent is usually required for processing special category data and for automated decision making. But usually consultants will require on some other legal basis to process most types of special category data. But where explicit consent is required, it's necessary to issue a privacy notice to the data subject to capture their explicit consent. You'll need to obtain evidence of consent captured and keep records of all consents so that you can equivocally demonstrate compliance with the consent requirements. Where processing is necessary to protect the vital interests of a data subject or another person, consent will not be required, but this will usually be in a life or death situation. Reliance on legitimate interests of the controller or a third party is a typical basis. One of those legitimate interests could be maintaining the healthcare practice and continuing to keep in touch with patients. Whatever the basis is, it will be necessary to set out what those legitimate interests are. I've noted earlier that there are many derogations in the GDPR, and it will still remain the case that there will be a patchwork quilt of different practices across the EU member states. And that's why the Data Protection Act 2018 provides a mechanism for the UK to exercise certain derogations. This presents challenges for businesses operating cross-border in trying to have a pan-European compliance programme. Inevitably, it will need to be tailored to the particularities of doing business in the relevant member state. The key focus of the new regime will be on accountability, and both data controllers and processors will need to demonstrate their compliance. And this has led to a great deal of investment in data audits, compliance programs, and data protection policies. But it's all about raising awareness and knowledge through sustained and appropriate staff and supplier training. The GDPR restricts personal data transfers outside the EEA to ensure an equivalent level of protection. You may only transfer personal data outside the EEA if one or a number of conditions applies. For example, that the EU Commission has issued a decision confirming that the relevant country to which the data is transferred ensures an adequate level of protection. But those countries can be counted on two hands. Alternatively, that there are appropriate safeguards in place, such as binding corporate rules or standard contractual clauses approved by the European Commission. Alternatively, that the data subject is given their explicit consent to the proposed transfer after being informed of the risks. Alternatively, that transfer is necessary for one of the reasons set out in the GDPR itself, which could include public interest, or to establish or exercise or defend legal claims, or protect the vital interests of the subject. Either way, a data controller will need to be satisfied that one of these requirements apply and should seek legal advice when determining whether those transfers are acceptable. This presentation has looked at some of the general requirements under the GDPR, but there are some specific issues for the healthcare sector. Data controllers are subject to certain rules and privacy laws, as we have seen. But in the healthcare sector, some specific issues clearly do arise. For example, a data subject's objection to direct marketing must be promptly honoured. Because the healthcare sector will be dealing with large amounts of special category data, such as healthcare data, there's a specific requirement under UK law for an appropriate policy document for how that special category data is processed. Even fundraising and marketing will raise specific data protection questions, even looking at information rights in videos or images, and dealing with subject access requests. So what should consultants and practices be doing in practice to ensure compliance? They need to identify any structures within the scope of the GDPR and that could be brought within its scope. They should be looking at situations where a subject access request from an employee or a patient might be made and how they will deal with that as a matter of practice. They should look at information already held about individuals, decide where it's held, is it necessary to retain it, and assess the risk of having to disclose it. Practices should be implementing data retention policies which allow out-of-date data or excessive data to be deleted, but balanced against the requirement to retain appropriate records. They should be considering other strategies to help protect existing data, such as technology solutions, encryption, and pseudonymization. It's wise to implement practice-specific data generation protocols, but in doing so, consider to what extent data about individuals needs to be created in the future as the practice develops. So consider how data is created and held with a view to minimizing it, but consistent with what is necessary. Many of you will have already implemented your data protection compliance program, but as noted, this requires ongoing effort. So whether you're seeking to refresh existing procedures or just checking that what you have done remains adequate, here are some action areas to consider. Do you know your data? Do you still have the same degree of visibility over what you're retaining or deleting as you did when you did the exercise in the first place? Identify the basis on which you're processing personal data. Are you processing for different reasons than the one you used to validate the collection in the outset? Take a look at your privacy notices, review and update them, and include the new mandatory information to ensure that the wording is clearly comprehensible to the audience. Review your information management and government arrangements to ensure that your compliance program remains fit for purpose. Do you have a data protection officer? Do you need to? Check whether you are required to appoint one, and if so, appoint a suitable person. Even if you don't, as a matter of practice, you will need to have an administrator or other responsible individual who can be a go-to person when questions arise and seek appropriate advice, and also put in place an escalation procedure for dealing with breaches. As I've noted, there's a temptation for obvious reasons to make precautionary applications, and the ICO has noted that around a third of those requests that are received are probably unnecessary. But if doubt does exist, it may well be sensible to err on the side of caution. But examples where this is not necessary might include where loss of the personal data is encrypted with very secure algorithms, which mean that it's backed up elsewhere. However, the question of the security arrangements would need to be probed in detail. Perhaps notification of data subjects is a more thorny issue. Under Article 34 of the GDPR, notification of the data subject is required without undue delay. Notification of data subjects is a more thorny issue. The GDPR requires notification of the data subject without undue delay when the personal data breach is likely to result in a high risk to the rights and freedoms of natural persons. If individual notification would be disproportionate, or public communication would achieve a similar effect, but only if equally effective. Controllers are required to implement privacy by design measures when processing personal data. This means that they must implement appropriate technical and organisational measures, such as pseudonymization, in an effective manner to ensure compliance with the data protection principles discussed earlier. So you must assess what privacy by design really means by taking into account the state of the art, the costs of implementation, the nature, scope, context and purposes of the processing, and the risks of varying likelihood and severity for the rights and freedoms of the data subjects posed by the processing. Data controllers must also conduct data protection impact assessments in relation to high-risk processing. It's probably unlikely that individual consultants engage in that, but in a large practice or in a practice handling very sensitive personal data, it can't be ruled out that requirement applies. Legal advice should be sought on this. Establish rules and procedures for data management across the organisation and its supply chain. Finally, test your current compliance and risk remediation strategy, identify any gaps, and put in place an improvement plan. In the event of any breach, the data commissioner will need to be satisfied that adequate steps have been put in place, and better to have a plan on how to do so than nothing at all. Individual consultants or private healthcare practices who are unsure about what they need to do to ensure continued compliance, or who wish to undertake a compliance readiness assessment, will not be alone. It's all about an integrated governance framework which requires audit and training, privacy policies, privacy by design, appointing data protection officers where required, ensuring that sharing agreements are in place with suppliers, customers and partners, ensuring that your data protection retention principles are robust, having adequate security in place, having intra-organisational structures to ensure compliance with the data protection requirements, and ensuring that that is the case for transfers to third-party organisations and outside the EU. These are some of the requirements. Overall, this integrated information governance framework should be proportionate and adequate to deal with the challenges of data protection and with appropriate protection for the rights of individuals. And as the Information Commissioner has said, compliance with the GDPR is not a one-off exercise. Unlike planning for the Y2K deadline, GDPR preparation doesn't end on the 25th of May 2018. It requires ongoing effort.